rise. Justice Court Part 13, town session. Honorable Judge Susan Baca presiding. Please be seated.
Good morning, everyone.
Morning, Your Honor.
I had to handle a couple of search warrants this morning, so please excuse me for being a few minutes late. Did somebody use our courtroom last week?
I don't think so. You think so? No, I probably came in and was it maybe?
So I stole my pen, adjusted my chair. Mr. Nance, you're here this morning on a case.
Yes, Your Honor.
Should we call that case first? Are you ready?
Yes, Your Honor.
Mr. Chesnoff, Mr. Schoenfeld,
We're ready, Your Honor.
State of Nevada versus Henry Ruggs, 21 CR 050378.
Morning, Your Honor. David Chesnoff, Richard Schoenfeld, and Mr. Ruggs are present, Your Honor.
Good morning. Do we have the Scram representative here this morning also?
We do, Your Honor.
President of the podium. Okay.
Present here in the courtroom.
All right, so Mr. Chesnoff, I received a document that you had filed this morning with the court.
I filed them on Friday, Your Honor. I guess the court was closed, so you received it this morning.
I did.
So we made two filings, Your Honor, and whenever the courts would like, I have some comments that I would like to make in support of the filings.
If it's all right with the state, I'll let you go ahead and speak, Mr. Chesnoff. Are you fine with that, Mr. Nance?
Sure, Judge.
Okay.
Thank you. May it please the court, under the U.S. Constitution, the Nevada Constitution, and statutory and case law, bail is a right not to be withheld, subject to conditions that adequately guarantee two things: protect against flight and protect against danger. In our case, the flight condition was met by a sizable bail amount and pretrial house arrest and no driving, which also merges into the second concern of danger, as Henry is confined to his home and therefore cannot drive. When he desires to go to our office or to doctor appointments, he contacts an officer, tells him when he will leave. He is then driven by others, and he also informs them when he will return. He has a log that he gets signed by myself or Mr. Schoenfeld or some other representative of our office or by the doctors that he's been visiting. So there is a strong mechanism in place to ensure he is not a danger. In fact, after one meeting with us, Henry had left our office, was leaving our building, and he remembered I hadn't signed the log and came back for me to sign it, showing how conscientious he is and respectful of the court and the bail process. He has been fully compliant. He has now completed 77 tests. The only issue of one missing test will be addressed as I proceed. When in custody, Your Honor, he was asked to provide his cell number for Scram to use. He gave it. Unbeknownst to Henry, having never been arrested before, he was unaware that Metro was seizing his phone, and he wouldn't have it. He gave the only cell number he had. He did that innocently and correctly, and it certainly wasn't inactive in his mind. It was his cell phone. He subsequently got a new phone, as Metro has not returned his phone, and that number was given to Scram. Let's talk, please, Your Honor, about the alleged missed call on 11/13 at 4:41 p.m. Henry was home. Two very reputable adults were with him. One a school teacher, the other the grandmother of his child. Miss Washington attests to the fact she was present with Henry, knows what the alert sounds like. She attests that at 4:41 they were in the kitchen preparing food and watching TV. She said she did not hear the alert that she had heard before. When Henry was first put on the system, Your Honor, he was given a calendar with ranges he could expect an alert, and we provided the court a copy of a portion of that. When he did not get the alert on the zone on the 13th, he proceeded to self and voluntary test to actively comply, and that test was negative. I would respectfully remind the court he has given 9 self-reporting tests beyond the required scheduled test and the Scram folks will attest to that. When he gave the voluntary test, having not heard the alert, that test was in the zone. If Henry had done anything wrong between his last test that he got a signal for and the one he gave when he didn't get the alert, we respectfully submit alcohol would have been detected. Plus, Your Honor, since it was in the zone on the calendar, if the signal had come at the time at the end of the calendar zone and he did take the test, it would have been Scram approved with the same negative result as the one he gave voluntarily. DeWillis Rivers is a school teacher from Alabama. He's been visiting Henry to show him support. He went to Henry's house on November 13th and arrived at 3:30 p.m. He brought ingredients from the store to cook with. He states he was in the kitchen with Henry and in close proximity to him. He had visited on prior days and had heard the alert. He knew what it sounded like. He also declared in his notarized statement that he did not hear the alert. Like Ms. Washington, he did not observe Henry consuming any alcohol either. So 3 people, including Henry, attest they did not hear the alert. It's on a wireless internet system, Your Honor. All of us know the vagaries of service, having experienced difficulties with just our cell phone service and the internet. Other clients of our firm have told us there have been times when they didn't get an alert. They let Scram know, and there were no consequences. I have spoken to the Scram folks, and they say it always alerts, except sometimes in rural areas. We don't want to quarrel with them, Your Honor. We know they do a great job. They're very concerned for the client, for the court, and the process. So I don't want to have an argument with them. But because of Henry's notoriety, Your Honor, we understand the heightened attention to this situation and why it was brought to your attention and why you wanted to deal with it seriously. We would note in another high-profile case that Mr. Schoenfeld and I were involved in, we had several missed tests, which led to stipulations with the district attorney and the court accepting that an error had occurred. Assuming arguendo, Your Honor, and again, we appreciate the work the Scram folks do in their professionalism and accessibility. Henry still did the right thing by testing during the window on his own when the test was missed. When Henry told me about the self-testing and that he hadn't heard the signal if it did transmit, he also told me he called 702-715-0032, as that was the number of a Scram agent on his calendar. We gave you a copy. He said no one answered that call. But then he said to me, should we call them together to report a problem? I said absolutely. We called the same number from my desk using his phone, and I heard him leave a voicemail regarding the schedule. Scram has verified that the voicemail was received. But here is something important for the court to know. Even though that was the number on the calendar, I was told by Scram they haven't monitored that number in a while, which means when they first told you of the missed test, they didn't know Henry had been proactive in trying to discuss the situation with them. They subsequently acknowledged that he tried to honor the court's order by discussing the problem with them and recovered the voicemail that I witnessed. Henry needs to remain on bail, Your Honor. We have proactively had Scram place the cam unit on his leg now that his cast has been removed. We didn't do that to be presumptuous, Your Honor, but we wanted you to know that we were taking this completely seriously. That system, as the court knows, provides for 24-hour reporting for Scram and the court, and it's all ready to go. Henry needs to assist his lawyers. He's also actively working with counselors on the trauma of the events in question, something that will be difficult to address in custody. He also has a series of medical examinations that relate to the injuries he received and also relate to potential head injuries. He has done everything Judge Bonaventure and you could have asked of the thousands of people addressing their DUI allegations. He should be given the same objective and judicious treatment that others receive. There's absolutely zero evidence that he has consumed alcohol, and he has tested negatively over 70 times. He's followed the rules above and beyond and should not be punished because his case has so much attention. I believe that if I ask Graham or the court asks Graham, they will tell you he is actually a great example of compliance and a model for others on release. One alleged mistest in the context of the facts before you, Your Honor, should not lead to anything but understanding by the court. I respectfully submit the court should maintain the status quo with the exception of the switch to cam. Thank you, Your Honor.
Thank you, Mr. Tisdale. Mr. Schoenfeld, did you have anything else to add?
No, thank you, Your Honor.
Mr. Nance, I'd like to hear from the state.
Judge, would you like to hear from the Scram representative?
That might be a great idea. Ms. Is it Rangel?
Yes, ma'am.
Would you come on up to the witness stand? I'm going to have you raise your right hand to be sworn.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, go ahead and have a seat if you'd like.
Ms. Rangel, if you would just please state and spell your name for the record.
It's Jennifer, or Angel.
Okay, please be seated. Mr. Nance?
Ma'am, who do you work for?
Scrum of Nevada.
And what is your role with Scram of Nevada?
I'm the program manager.
And as program manager, do you have access to all the systems that might be involved and relevant to this situation involving Mr. Rhodes?
Yes, I do.
I understand he's been mostly in compliance except for one particular mistest. Is that true?
That is correct.
When someone gets signed up to receive text alerts about when they're supposed to test and so on, how does that process work?
It can either be done at the jail, like as Mr. Red's situation, where he went down to house arrest and put him on the device, or they can come into our office.
Through that process of signing up, is a client made known that they should be receiving text message alerts about when they're supposed to test?
It is an optional feature that we have. Some
Okay.
choose to opt out of it, and some choose to accept it.
Do you know whether Mr. Rhodes opted in or opted out?
He had opted in.
Okay, so as far as how he signed up, he should have been expecting text messages, correct?
Correct.
Okay. Now, have you investigated the circumstances of this failure?
Actually, the parent company, the manufacturer, AMS, has investigated the back end.
Okay.
Details that I don't have access to.
Okay. As far as the details you have access to, are you able to determine what happened with the cell phone and what happened with the text alerts?
The device gave as it should normally, with the testing window opening up at 4:01 and then closing at 4:41.
Okay. And
There was no errors from cellular or otherwise.
okay. And are we talking about the device that's in his home to alert him, or are we talking about cell phone text alerts?
We're talking about the device that's in his home.
And the device that's in his home, could you briefly describe to us, if we were in Mr. Rhodes' home, what should happen, what should we hear when the alert happens?
It makes a time, I wish I got one actually. It makes a timed alert, and it says it's time to blow, and that window will stay open. And it basically, it keeps on blowing consistently until either the window closes or the test is taken.
And regarding this missed event, from your end in the Scram system, you were able to determine that the device is operating correctly?
Yes.
If the device did not have an internet connection of some kind, would you be able to determine that?
It's not through internet, it's actually through cellular towers.
Okay, but there is some kind of data connection?
Yes, it's all through cellular, though it's not required for Wi-Fi.
And would you be able to tell if the device was online based on Scram systems?
Correct.
And as far as your investigation of that device, was it online or offline?
It was offline.
And so then, as far as you know, the Scram device was operating as it should.
Correct.
And with it operating as it should, nevertheless, we have this missed test that we're here to talk about.
Correct.
Okay. Subsequent to the missed test, do you know what steps Mr. Ruggs took to correct or remediate that incident?
I actually did call his counsel on Tuesday and noticed, because I noticed in the system at the time when I was investigating that missed test, that it was an invalid cell phone number on the text reminders. So I contacted his counsel, and he kept three-way called Henry, and Henry gave me his updated cell phone number that I then put in the system on Tuesday.
Okay, and when you're discussing an invalid cell phone number, what does that mean essentially in this context?
It means that the system was attempting to send text messages but was unable to deliver them. When I attempted to call the same number for Mr. Ruggs that had listed, it had gone straight to voicemail. The mailbox was full. That's why I contacted his counsel. So the
Okay.
system was attempting to send those reminders but was unable to do so.
Okay.
And so it moved the number to invalid after 7 days.
All right, and as we sit here today, this alerting device, is it still installed in Mr. Ruggs' home?
It's a handheld portable breathalyzer, so he takes it with him.
And that's the device that makes the noise that we're talking about?
Correct.
Okay. And so he's instructed to have that with him at all times?
Correct.
In his home, out of his home, if he's on an allowed venture outside his home?
Everywhere he goes.
Okay. And Scram has the ability to continuously monitor whether that device is connected and working properly?
At the time of test windows, yes, or I could send an on-demand test that would, the device would then behave as if it was time for him to take a test.
Okay. And because of this incident, did Scram provide or install additional equipment onto the defendant, Mr. Ruggs, to avoid this type of situation in the future?
His counsel was requested that he be placed on a CAM device.
And a CAM device, could you explain what that is?
It's a continual alcohol monitoring device that takes a sample from the skin approximately every 30 minutes.
And is that the same thing that we would understand as sort of an anklet or a bracelet type
Correct.
device?
Correct. It's technically the Scram, which is secure continual alcohol monitoring.
And that device requires no additional input from the defendant to get an accurate reading?
That's correct.
It's just there, and if there's a problem, it alerts Scram?
Correct.
And if there's not a problem, that is also recorded in the system?
Correct.
So it removes the affirmative nature of his current situation where he has to take steps to check in?
Correct.
And at all times, you're able to check to make sure that ankle device is working properly?
Correct.
Okay. If for some reason Mr. Ruggs determines that device is not working correctly, under your rules, does he have a duty to report that to you?
Yes, he does.
And since, I guess, he has it on now, has he reported any problems with the device?
No, he does not.
Now, going back to the cell phone text alerts that are provided to Scram so that they can get text reminders about the previous device, you call those questions? It is the client's duty to provide a number where he can be reached. Is that fair to say?
Correct.
You can only reach him by the number he provides.
Correct.
And he is aware that he's supposed to get text messages.
Yes, correct.
I have nothing further, Judge.
Mr. Chesnoff, do you have any follow-up questions for Mr.
Just briefly. With respect to the last questions about the cell phone, the instructions are given right after he was arrested, correct?
Correct.
He's in a jail setting, correct?
Correct.
He'd been injured, at least from some of the visible evidence, like a cast on his leg, correct?
Correct.
He couldn't do the cam at the time because he had the cast on, correct?
Correct.
He gave his cell number, correct?
Correct.
He didn't give a fake cell number.
Correct.
And he had no idea at the time, from anything he said to you or any representative, that the police were going to keep his phone, correct?
That is correct.
And then when we were informed that this was an issue, Mr. Ruggs immediately provided you with a new cell number because the police have never given him his phone back, correct?
That's correct.
How long have you been with Scram here?
I'm starting May 3rd of this year.
Okay, and you've dealt with hundreds and hundreds of defendants in DUI cases, is that
Yes.
fair? Would you please, if you can, give your opinion to Her Honor about the level of cooperation and compliance that Mr. Ruggs has shown during the process?
He's been extremely cooperative. He's actually taken 9 separate tests that are self-initiated over and above what his 4 random tests have been per day.
So he's trying to show that not only during the windows that you people would alert him, he's also showing you that at other times he's been compliant.
Correct.
And when you've spoken to him, he's been cooperative and hasn't tried to evade your questions. Is that fair?
Correct. Very fair.
Okay. And if everybody that was on Scram was as compliant as Mr. Ruggs, would make your job a lot easier, wouldn't it?
It would.
Court's indulgent. Okay. Good question. Okay. Do you believe in your experience as the manager of Scram that the new CAM method is a good way to alleviate any concerns in the future with respect to Mr. Ruggs's following the directives of the court.
Yes, I did.
And of course, he cooperated with that completely, correct?
Yes, he did.
We invited you to my office,
That is correct.
and then you put it on,
Yep.
and I guess I just learned it's up and running?
Yes.
Okay. I have nothing further, Your Honor.
Mr. Nance?
And just briefly, the ankle device that we're discussing at this point, does it also have some sort of GPS capability built into it?
No, it does not.
Okay, so if he has what we call high-level electronic monitoring or other house arrest features, is that a separate device?
Correct.
Does Scram have a device that does have GPS built into it?
Yes, they do.
Why are we not using a GPS device plus the alcohol monitoring device?
Because he already has the GPS device on through CCDC.
Does that require two separate devices then?
Yes.
Okay. Nothing further, Judge.
Anything else?
No, thank you.
I do have a question.
Yes, ma'am.
So the ankle bracelet, when was that put on Mr. Ruggs?
On Friday afternoon at 2 o'clock?
And would you say that that's a higher level of monitoring of Mr. Ruggs than the handheld device?
Yes.
Okay, because this one is a 24-hour device.
Correct.
Okay. And this one does, if Mr. Ruggs were to consume any alcohol, it would test it from his skin to the device from sweat. Is that correct?
Correct. It's a transdermal alcohol.
Okay,
Your Honor, may I ask you one more question?
of course.
If you heard my remarks earlier, I talked about the phone number that Mr. Ruggs called when he was trying to communicate that there had been a problem. That was the phone number that was on the calendar, correct?
That is correct.
And that phone number was not being regularly monitored, correct?
Correct.
But after I brought to your attention that he had tried to talk to you, you went and you found the actual voicemail that he left,
That
correct?
is correct.
Thank you.
Anything else, Mr. Nance?
If the defendant has any further problems from his perspective of complying with the court conditions,
That's his test, actually. He's getting prompted to take his test.
Your Honor,
That's not intentional.
He's got a few minutes.
his device is now going off, he just told me.
Okay.
is it fair to say we can ignore that one?
That's up to the court.
That's up to the court. We're not, I'll take it if I have to.
He's got that.
My question.
We should be finished momentarily.
Okay,
You have
thank
a
you.
window of
Yeah,
time to
yeah.
respond.
Thank you, Your Honor.
My question, ma'am, is regarding this phone number that he was supposed to call in the event of a problem that was not monitored. At this point, if he has any problem with his ankle device, somehow it comes detached, it's malfunctioning, obviously. If anything goes wrong for Mr. Ruggs, does he have, without doubt, a phone number where he can get a live human at any time to discuss the problem?
Yes, in addition to the number that was printed on his schedule, he also had access to my business card. And the following day, after I had enrolled him at the jail for the remote breath, I did contact his attorney because I needed further paperwork filled out. So there was access ways of getting a hold of me.
Okay, and then should he have any of those type of problems in the future, Scram is ready, willing, and able to provide a person with knowledge to come in and explain any type of violation from the equipment side of things, and so on if there are future problems.
Yes, he has my direct line.
And Scram will go above and beyond to provide some of those explaining those issues should they occur.
Yes.
Nothing further, Your Honor.
So, Ms. Ringel, so in addition to the telephone number that you have for Mr. Ruggs, you also have his attorney's telephone number if there's some problem in miscommunication when you are not able to get a hold of Mr. Ruggs. Is that correct?
Yes.
And do you have any other numbers other than Mr. Ruggs' number or Mr. Tesnoff's number?
Yes, I have his emergency contact information that he provided.
All right, so there are additional ways for you to get in touch with Mr. Ruggs in case there's a malfunction or something goes wrong with this current ankle monitor that he's on.
That is correct.
Thank you. Anything else?
No, thank you, Your Honor.
You may sit down. Thank you. Mr. Nance, I'd like to hear from the state.
Judge, these are the court's conditions to protect the community and to ensure that Mr. Ruggs comes back to court when he's supposed to. It appears that he's done a fairly good job at that, except for this one incident. You heard from the Scram representative that regardless of what the defendant says and his two affidavit witnesses attached to his pleading, according to Scram, the device functioned as it should have. That is something that I'm a bit concerned about. Some uncertainty there, but these are the court's conditions. So you ultimately have to make the decision whether these are sufficient to fulfill these purposes of bail. I believe that going forward, additional measures that weren't in place have been provided that may alleviate this type of situation in the future. But from the outset, the defendant is the one responsible for the situation. The defendant was given his conditions. The defendant has a set of attorneys that have been through this multiple times that would have known his cell phone would be held as evidence. The defendant was aware that he was supposed to be getting cell phone check-ins. I think it's a problem that he did not recognize that for, it looks like, a period of a couple of weeks. And whatever happens today, whatever the court decides, I think that it should be crystal clear that future violations of any kind should not be tolerated and should be judged and dealt with the utmost severity.
Thank you, Mr. Nance. Mr. Ruggs, so there was a miscommunication, it sounds like, between you and Scram. It's your place, it's your responsibility to make sure if there are any changes in your telephone numbers, your address, or anything else going on with you. Number one, I assume that you let Mr. Chesnoff and Mr. Schoenfeld know that you had a new telephone number.
Yes, sir.
Did you notify house arrest that you had a new telephone number?
Yes, sir.
Okay, so you should have notified Scram that you had a new telephone number, okay? One of the things I don't like about the handheld device is it's easy to be problematic. If you're taking an extra long shower or something like that, you can miss, and it does happen. I much prefer the ankle monitor. I understand when Judge Bonaventure first imposed conditions that he imposed the ankle monitor, but because of your injuries at the time, you weren't able to have two ankle monitors on the same leg because they need to be on separate legs, correct? Okay. So now we have a higher level of monitoring for you, which is being done 24 hours a day, all right? I am very thankful that you and your attorneys took those steps to go on this higher level of monitoring, okay? And as everybody knows, this is a high-profile case, all right? But you have to be treated the same as any other defendant, as any other person that appears before the court, okay? So now that you know if there are any changes, you have at least 3 separate notifications that you should make to Scram, to house arrest, and to your attorneys if there are any problems at all, okay? And as I'm sure you're aware, this bracelet is going to monitor you 24 hours a day. And this court has heard every excuse in the book, from lotion to shampoo to body wash that causes a monitor to go off, all right? And I don't believe in any of that, all right? I've heard it all. In the 10 years that I have been presiding over this calendar, I have heard every excuse in the book. So if you find it incumbent to get body wash, lotion that does not have any alcohol content in it, that's great. But there's not enough alcohol content in any of that to set off the device. Are we clear? Okay. So I'm sure that people are going to wonder, obviously we have a courtroom full of people today, but the court is comfortable, it appears that the state is comfortable with what we've heard today, that with the higher level of alcohol monitoring with a 24-hour device on your ankle, that is enough to satisfy the community, to satisfy the court that you're doing what you're supposed to do. But if there are any if there are any problems, if there's any alcohol detected in your system, you need to know that that's going to be problematic for this court going forward. I'm sure there will be a lot of questions as to why bail isn't revoked today because of one missed problem. As the statute is written, it wouldn't allow me today to revoke your bail. I want to be very clear on that. I could increase your bail. I could hold you in contempt of court and put you in custody for a few days. But I'm not going to do that. You made the steps to do what you're supposed to do, and you were on a higher level monitoring. So again, let's reiterate, you're on house arrest, you have an ankle bracelet on that monitors you 24 hours a day, you have a no consumption of alcohol or drugs, I would assume, as well as your release conditions, and no driving. Okay? So you need to continue to be in perfect compliance going forward. Do you understand? All right, thank you.
Your Honor, is it the order of the court that the handheld device be replaced with the ankle monitor device?
That is the order of the court that the handheld device be replaced with the ankle monitoring device, because the ankle monitoring device is a 24-hour monitoring device as opposed to you doing a random test 4 times a day. It's more reliable. You just have to make sure you charge it and don't forget to charge it. Okay?
Your Honor, should we test, though, now that the alert went off, just so that it doesn't show as a missed test?
Absolutely. I think that that would be a great thing to do, Mr. Chesnoff.
Thank you.
And if you guys want to do that out in the hallway, that's fine.
That would be great,
So it's
yeah.
not being done in front of the cameras. Okay?
Thank you.
Thank you, Your Honor.
All right, we have another hearing, I believe, December 8th. Is that our next one?
Yes, that's correct, Your Honor.
Okay.
We'll see you then, Your Honor.
See you
Thank you.
then. Thank you, everyone.
Come on, come on, come on.